Okay.
Does the city have anything further to place?
No, at this point, with the exception of preserving the right to call rebuttal witnesses, the city rests its case in chief.
As the city rests, I think that, I don't think it's defense, but the respondents would move for a motion to dismiss if the panel would hear that.
We'd obviously defer to the panel, but I don't know that the procedures provide for such a motion here.
There aren't many procedures that we have except for the Administrative Services Act, but I think we're entitled to at least put it on the record that we believe that the evidence is not, that was presented so far has not been sufficient for purposes of any type of debarment, let alone debarment in the instances. I can be more specific about it, but you might want to make a ruling as to whether or not we're allowed to make a motion.
Well, I need to make a report. Give it 5 minutes.
Allowed. And I would make it on behalf of GAP, and I think Mr. McDermott would make it on behalf of Empire. So, sitting at a debarment hearing today, which is an extreme sanction for which there is actually no standards under the law. The testimony that we've heard today was basically 2 parts on 2 city contracts, total of 3 city contracts. Let's talk about the Moss and the distant contracts, because there was no minority participation requirement, and there was no issue with regard to the GAP, what GAP did or didn't do on that contract. GAP was contracted by Empire to perform that work. It had no standards with regard to whether or not there was minority participation. More importantly than not, you guys saw it. Those contracts, minority participation was actually met from GAP. So for the city to come in here and take that little issue, that little circumstance, which may be a violation of the contract perhaps, and a breach of contract for damages, but it doesn't rise to the level of a fraud, it doesn't rise to the level of a violation of the contract that would require any type of debarment. It doesn't rise to that level, at least as it goes to GAP. All GAP did was perform the work. That does not suggest one way or the other whether GAP was a front for the Empire, nor does it prove anything with regard to the issue we're talking about, which is the City Executive Order 312, which by the way itself may be unconstitutional, but that's a legal argument. But the City 312, how do we violate that? How do we violate any contract in the Moss distant playgrounds? GAP did nothing on those contracts to violate any of those contracts. The second component to that, we have an issue with regard to the plumbing and heating contract. And we acknowledge and we admit that that's a GAP contract. And what do we have here? We have backhoe sales, backhoe rentals from a few occasions in the 2018 and 2019 period. And what we have, which will be explained by Mr. Wallace in his testimony, is we have unexplained issues with regard to a backhoe. But the city or the investigators, they wouldn't accept the testimony of Mr. Wallace. They won't accept the testimony at all because they want to reach a certain conclusion. So just those backhoe controls or 2 little contracts of labor, are those issues sufficient to cause a debarment? Are those issues sufficient to show that there was a pass-through entity? You don't, and then they don't look at the rest of the contract. They don't look at the rest of the work that Empire is doing. From our perspective, from a legal perspective, and even from a factual perspective, on both the 3 contracts that we're talking about, Moss Distant is one, and the plumbing and heating contract, there hasn't been any violation of the Executive Order 312. There hasn't been any violation of the contract itself with the plumbing and heating, and there's been no violation of the contract itself for Moss and Distant by GAP. So I don't know why we're sitting here. So based upon that information, we're going to move to dismiss.
Thank you. On behalf of Empire, in reference to the 2 playground contracts, you've heard a lot of testimony, seen a lot of records regarding that, but it wasn't a minority contract. The only thing, given the city's evidence in the best light, they have potentially shown that Empire may have potentially breached the contract that it had with the Angelo brothers, and that's it. There was no minority contract part of that. There's no showing that my client had any knowledge of that. My client never sought any type of credit for that with regard to MBE. And everything he did was legal under the contract, except for not get permission to subcontract. And that's not something that should bar him for the very reason we're here. As with the third contract, there's no showing whatsoever that Empire did anything wrong. It never sought any credit for any MBEs resulting from that. Never broke any contract with anyone. Never did anything that would have him disbarred as a result of that. This is a case where the city's burden of proof is not all that high. However, if you don't have any proof at all, you don't need any burden of proof. And all they have is a potential breach of contract by Empire. It should be dismissed.
We're gonna overrule.
One, is there any response from the city?
I can respond very briefly just to say, I don't want to waste the panel's time, but in brief, the point here is not that Empire and Gap just simply broke some contract between Empire and D'Angelo. The point is that D'Angelo's contract with the city for rebuild had an MBE requirement. Empire knew that because it submitted or it claimed that it had done work so that D'Angelo could get MBE credit on that contract, right? And as we've heard today repeatedly, the Mehans, who are also part of GAP, are also partners in Empire, and so that conduct is attributable to them as well. As to the plumbing and heating contract, what I basically heard was an argument that the sanction shouldn't be a 3-year debarment, that it should be something else, because it's basically just a little bit of fraud. We just lied to the city a couple of times, is what I was hearing. But I didn't really hear any response to the fact that GAP claimed MBE credit and that Empire certified that it provided equipment and services that the evidence shows they did not. And so it's very clear here that GAP and Empire both violated, lied to the city on multiple contracts on multiple occasions, allowed others to claim that they had done work so that MBE credit could be claimed. And that's enough for the panel, certainly to impose some sanction, as we'll argue at the end of this hearing, a 3-year debarment.
We're going to overrule the motion to dismiss.
Are you overruling the motion to dismiss, or is council overruling the motion to dismiss?
The panel is overruling.
I have seen no conversation with 2 panel members. I've seen one conversation
Hold
between
on.
you and council, and he told you to overrule it.
Yeah, panel is in agreement.
So should I say that the panel is overruling the motion to dismiss?
I put my statement on the record.
And our statement is correct. Panel is overruling the motion to dismiss.
Can we just clarify, making motions to dismiss, because there were 10, just so that we're clear.
We are going to adjourn for the day, and we will resume on Wednesday. Correct one year for that night.
I'm not available on Wednesday.
Adjourn for the day.